Hello, welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards, Wellman, Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a column that I co-author that appears each month in the IEEE's Computer magazine. That column discusses the legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, we discussed design patents. In this podcast, we will discuss patent monetization, a topic that we covered in our April 2013 column in Computer magazine. Joining me today for this podcast is my colleague Ralph Lauren. Ralph is a partner in the Boston office of Edwards, Wellman, Palmer. Welcome, Ralph.
Thank you, Brian.
Ralph, as we said in our column, monetization is the new buzzword. It's being promoted heavily as a way to make money off of patents that aren't otherwise being used. At one extreme, you have the so-called patent trolls, companies that own patents, don't produce anything, and go around suing others for infringing those patents, sometimes on the basis of questionable facts. At the other extreme, you find companies and institutions, particularly academic institutions, that have many patents but haven't determined how to exploit them fully. Those patents tend to languish. Let's assume that you own some patents that you're not using. Is there a way to estimate the amount of revenue that these patents could generate?
Well, that's a sort of difficult question, Brian. Patent valuation is sort of an art, not really a science, though a number of people do it. Basically, you look at what you could get to sell it or license it. Those are the two normal ways of getting value on it. And certain companies, such as some of the accounting firms, there are specialists in patent valuation. All of them look at the history of what the patents in that technology have generated in revenue, and then from that can get a feel for what the valuation may be for a patent.
What's more common, bundling several patents together into one group to monetize, or monetizing on a patent-by-patent basis?
Well, it's too bad, but it's often a matter that people look at one patent and try to value that and monetize that, when really bundling is probably a better idea. If you have related patents that cover the same or related technology, that's probably a better way of doing it. You don't want to have a patent and license one and somehow potentially be stopped by another. People want the whole bundle of technology at once.
Could that also cover instances, for example, where you might have patents to a method of producing an item as well as on the item itself?
That's one of the classic areas of doing this. If you're trying to get the patent and someone has a patent on a special method of producing it or using it, those are things really should be combined into one patent portfolio or patent bundle, really, that's licensed or sold as one.
And similar to our topic last month, you also have the issue of design patents, where you might have a design patent that covers the look and feel of an object, but then a utility patent that covers the function of the object. That would seem to be a candidate to be bundled.
It's a classic way of bundling. You put these together because the design patent is really not valuable without the function. The functional aspect may be improved by the design.
Well, there are basically two ways to generate the revenue, and you alluded to this earlier. You sell the patent outright and maintain ownership, or rather, maintain ownership by licensing the patent. Is one preferred over the other?
Well, normally licensing has some preference to ownership sale. When you sell something outright, you're not retaining a right to use it yourself, if there's any possibility you would use it. You can license back, but that's not normally an optimum situation. When you sell something, it's also hard to value because you're basically are accelerating the amount of money at the start, but because of the questions about how much it will actually earn, the total amount you get is likely to be less. If you license it, you may use a combination of factors. You can get all the money at once. You can get some of it at the start and then a royalty stream going forward. You may have milestone payments. There's a variety of different ways to accomplish this.
What about issues of control on the technology? If a company decides to sell its patents outright, and as you said, they really don't have any claim to them going forward, how can they maintain some control of their technology? Or maybe said differently, are they exposing themselves to a risk where maybe they might not be able to operate in that technology space any longer?
That sometimes is a case. If you have the patents, selling them outright is really only a good solution if you're really leaving that technology space. As I said, it's possible to license it back, but it's not optimum. You'd like to have it so you are licensing if you're potentially going to work in that technological field. If you're not going to work there and they're just sitting on the shelf, then you might as well sell them.
And I think that's something that would happen if you find a company acquiring another company and perhaps inheriting some technology that's no longer important to the future of the newly combined entity, and maybe the newly combined entity just decides to sell off some technology portion of its business because it's just not going to exploit it any further.
That happens a lot. It's definitely on a merger. It can happen. It can happen where a large company, for example, decides we're no longer going to keep this product line or the business line, and they may just drop that, in which case then they've got a series of patents that cover it, and they either can license them out or sell them outright, because that may give them immediate amounts of money and somehow potentially reduce the accounting loss they'd have otherwise.
Now, you mentioned the licensing a moment ago. If the patent owner does decide to license, it can grant an exclusive or a non-exclusive license. Can you explain the difference between these licenses and what some factors are you should consider before deciding which version to pursue?
Okay, a true exclusive license excludes everyone except the person it's licensed to, including the patent owner himself, can't use the technology. One often speaks of an exclusive license with a right to use for research purposes. Universities are renowned to do this. They grant what's called an exclusive license, retaining a right to practice it themselves solely for limited purposes, but not for commercial purposes. A non-exclusive license is something that you can use. You license multiple people, or you keep the right yourself to use it. It's used a lot where you have a basic technology that has a lot of applications, and you get a number of people who would like to use it. In that circumstance, you may give a whole series of non-exclusive licenses to various people in the field.
What about the relative royalty rates of exclusive versus non-exclusive licenses? Are they generally different?
Yes, normally an exclusive license, which is akin to a sale in a lot of ways, is a much higher royalty rate than a non-exclusive license, possibly, a factor of 3 or 4 different.
Thanks, Ralph, for your views on this. It's not uncommon for patent owners to be faced with significant costs to maintain their patent portfolios. These costs include the periodic maintenance fees that the patent owners pay to the governments that issued the patents. For example, in the U.S., these fees are due at 3.5, 7.5, and 11.5 years after a patent issues. One way to offset these costs, and maybe recoup some of the cost incurred to obtain the patents, is to look for ways where the patents are not already licensed or otherwise used and can be turned into revenue generators. The process for doing that, monetization, entails a thorough review of the patent portfolio and an aggressive search for potential licensees or buyers. Although it's rare to find a Rembrandt in the attic, an earnest attempt at monetization can lead to some unexpected revenue. We hope that you found this podcast helpful in understanding some issues about monetization. Stay tuned for our next installment in Computer Magazine. Until next time, this is Brian Gaff.
And Ralph Lauren.
Feel free to contact us via email at bgaff@edwardswildman.com.
Or at rlauren@edwardswildman.com.
Thank you.